I want to talk to you guys about Hartford long-term disability denials and the remedies after you've been denied. And specifically, I want to focus on appeals. And so, Alex, you know that under the law of ERISA, which is what 99% of these Hartford group employer provided disability policies are governed by, require a claimant to file an appeal. Can you talk about why it's so important to have, well, I don't want to just say have a lawyer, but to submit a super strong appeal, which I don't believe you can do without a lawyer, but why it's so important to put in the absolute best possible appeal in order to win your benefits back?
So the purpose of an appeal, what you said, is required. It's before you can file a lawsuit. You can't file a lawsuit until the insurance company renders a decision on your appeal. So the appeal gives you one last chance to do two things. Actually, it gives one last chance to do two things. One, get yourself back on claim with the appeal. And two,
if you've ever been paid. Some people haven't been paid
right,
at all.
Or get yourself back on claim or get your claim approved with this appeal. And it's also the last time you could possibly strengthen your file for a lawsuit. If the insurance company denies your appeal, the claim file closes. The claim file is the set of papers, all the documents that they compiled, all the documents they created, all the documents you sent in or your doctor sent in, is all put into this claim file. On the date the insurance company denies the appeal, the claim file is closed, and the judge who's going to render a decision on your lawsuit only gets that claim file. If the day after the insurance company denies your claim, you go, oh, here's the results of an MRI I had done 2 weeks ago. Not going to get in there. If you get hit by a bus the next day, not going to get in there. So your appeal is twofold. It's to convince the insurance company that their decision was wrong or misguided or arbitrary and capricious, and it's also to strengthen your claim file. It's so important that it's done right. I see people doing their own appeals, and I get their claim for a lawsuit, and I go, I put my hand to my head and go, geez, there's so much we could have done here to give you a fighting chance on the lawsuit. And maybe I'll still take on their lawsuit to do the best job I possibly can, but we could have made it so much stronger if I did the appeal myself. And myself personally, I've done over 1,000 appeals. So it's not my first, first time, doing an appeal. It's not my first rodeo, as they say. So we know the arguments to make and the strategies to take and what needs to be done before you file the appeal, what you write in the appeal, and what you submit with the appeal.
So segueing from what Alex just said, how we know the strategies, what is your strategy when dealing specifically with a Hartford disability appeal?
Normally we get an idea of formulating what we're going to want to do from the denial letter. From that initial review of the denial letter, we can understand definition of disabilities, or your own occupation, any occupation, what the medical conditions are, like what can we do to bolster it. So first thing, just from a procedural standpoint, is requesting the claim file, like Alex mentioned, and that claim file has to be given to you. That's one of the perks of this area of the law. They have to turn over everything that they've done, and going into an earlier, discussion about video surveillance and stuff, have to turn all that over. And sometimes we'll see the claim file, we'll see that they did do video surveillance but caught nothing. That's why it's not in the denial letter. So using that to your benefit. So you do get that. Now they're going to have 30 days to provide that to you. Ever since COVID, they've become much better at like sending links for download. So they're generally quicker about it, but they still have 30 days. So during that time, it's also requesting all
Before you go beyond the claim file, I want people who've never been in this don't understand that this claim file can be a minimum of 200 pages to, over 10,000 pages if we have claimants who have been on claim for years. So it can be extremely voluminous.
I was speaking to a client the other day and I said, yours is 422 pages. I don't know if this is the whole thing. He's like, I thought that was a lot. I'm like, no, it's not, And there's a lot of duplicative information, and even the way that they do some of their own internal note keeping for reviews and stuff, it's like buried in. So sometimes it's very hard to find. So while that's pending and waiting, requesting updated medical records, I'm also of the opinion that I don't trust that Hartford had gotten everything. Getting the records for ourselves and then thinking about what additional testing can be done. If it's a physical restriction type case, functional capacity testing, work simulation exams. If the person hasn't had an MRI in a couple years or something of that nature, what additional testing can we use to bolster it so that when we do get that claim file, we do have the ability, we're ahead of the curve to be able to start processing things, sooner. And I think one thing, kind of going back to what Alex was talking about earlier, and I've had plenty of people tell me with Hartford that after their claim's denied, they get hey, you just have to submit a letter, telling us why. And then people have told me that the claims rep has advised them, oh, you don't get an attorney involved unless there's a denial of it, which is certainly not the case. So, you always have to take what they're saying with a grain of salt, nor do they ever tell you, even though it says it in the letter and all the form language, that you have a right to get your whole file. Like, you know, they're not on the phone coaching you through it or anything of that nature. So, you know, I think it's really a matter of coordinating with the client, with the doctors, trying to make sure doctors are going to get on board. You know, the nuts and bolts of what's going to give you the best chance to win your appeal. Because ultimately the appeal is getting to the money, right? And it's going to happen one of three ways. We get you on claim. If there's a denial and there's litigation, giving you the best chance to win. And even in litigation, if following a denial, they're going to want to look for mediation, potential settlements. The stronger your appeal is, the more value your claim has. So it's going through everything that you possibly can to strengthen the medical support.
Right. I always like to tell people about the appeals. It's like you're preparing for an attack and you want to build the greatest, biggest shield / fort that you can possibly build. And you have the opportunity to do that in this administrative process because there's no rules of evidence. We're not in court and we can throw everything and anything in there to support your claim. And likely Hartford's going to look at some of it. They're not going to look at everything, but we want to have that ammunition in the event that we don't win the appeal, because the next remedy is a lawsuit, which is we have separate videos talking about lawsuits and, you know, and what you do if you lose your appeal. But you really have to think a little bit outside the box and you got to build the evidence. And it's not all about just throwing in case law, meaning other cases have been decided and all that stuff. We barely ever do that. We know the case law. We apply everything we know because we're kind of like artists in doing these appeals, but it all comes down to getting that evidence. And we have all the tools, like you've mentioned, outside doctors, outside vocational experts, to really put forward a great appeal. And like we tell people when we talk in our videos on our website, call us, email us, send us a request or call us. We just want to look at your denial letter initially. We'll let you know right away if we can help you. No fees or costs unless we're able to win, and we're going to be totally candid. You know, we think you can win, or sorry, we don't think this is a case that you can win on. So anywhere in the country we can help, and we look forward to speaking with you about that.